Would like to welcome everybody to the Pinal County Board of Supervisors special session. To begin with, item number 1 is an executive session. Could I get a motion to go into executive session?
Mr. Chair, I move we recess the the work session and convene executive session.
Okay.
Second.
I've got a motion and a second. All in favor say aye.
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 Any opposed?
Nay.
We have the executive session. Okay, we have the motion. Do we have a second?
Second.
All in favor say aye.
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 Any opposed? Ayes have it. Okay, item number 2. We've got some scheduling conflicts that have come up on us, and so we're trying to, for the sake of keeping this meeting on task, I'm going to actually move this item to the first work session in August. Do you have a date for that?
Yes, Chairman. The actual work session of the month of August is going to be August the 14th.
Okay. And the reason for that is I want to give our human resources ample time to be able to give the presentation as well as allow us as board members to discuss it. So, thank you. Okay, item number 3. No, there's no action item, so this is something as the chairman I can do. Item number 3 is discussion of revisions to the county ordinance number 111099 R20 adopted in 1999. Let's see, we've got Chris and Ian and Joe.
Mr. Chairman,
Yes.
members of the board, let me just set the stage a little on this, and then I'll turn it over to Ian. And then I also know Joe is here and Brenda's here, can also answer some questions regarding this. This is our attempt to add another tool to our toolbox when it comes to certain types of code enforcement, specifically rubbish, trash, and debris, and burn down buildings and the like. We have been going through this one way, and lo and behold, we do have an ordinance that would allow us to go another way, but it's outdated. It hasn't kept step with the statutory changes over the years, and we wanted to present this to you and explain how it may be of use and how it may help streamline and expedite some code-type cases. Not all, but only a certain category. So with that, Ian's prepared a short slide presentation, and I'll walk you through what we're contemplating. And if the board then has an interest in pursuing this, we would go through the ordinance process. We would draft it. We have one already, semi-drafted, depending on what kind of feedback we get. That would have to be published, public hearing, and so forth before it even takes effect, if that is the board's desire. So, this is just the first step. Should you so desire, you could say, we're fine with what we're doing. We don't need this.
Okay. All right. Thank you. Ian?
Good morning, Chairman, Supervisors. So this is essentially a short presentation, just giving an overview of essentially 3 parts. First part is the background, the current state of our code cases, and then the second part is our current process, and the third part is the proposed new process. So just going off of what Chris said, here's the numbers essentially to show you all where we're at. These numbers are recent as of March of 2024. So we have a total of 602 cases, 495, so almost 500 of those are active zoning code cases. Of those, there are just over 100 that are building code cases. So these would be just relating to zoning type issues. Now, as of May, only 17 cases of the 602 are proactive, meaning there was not a complaining party that initiated it, but they came up in the course of some other, whether someone applied for a permit or any other way that a proactive case was generated. So we're only talking about 17 cases as the proactive. So there are, as I said, a little over 600 cases, and those are being handled currently by a total of 7 staff members. So there's one building safety inspector who is handling all the building code cases, and we're talking over 100 of them.
Yeah, you bet. It's a work session.
Thank you, Mr. Chairman. So can you give me an example of a zoning case that's not a building case, and then an example of a building code? Zoning would be like, well, they're running a store in a neighborhood.
Correct, or inoperable vehicle, for example.
So an inoperable vehicle is a zoning issue.
Correct. Under our current code, yes.
Okay. And a building would be, we'll cut out the idea that they didn't get a permit, but what other one would, what would be another building?
An unauthorized, let's say, accessory building, for example.
Well, they didn't get a permit.
Right. Erecting walls that are too tall, or walls in the front where it doesn't meet a setback because it's up to the curb and it's now affecting, sight lines going around. Or like I said, they're only allowed to have a 6-foot wall and they built a 10-foot wall.
Okay. But that would have not, that seems to me would have popped up in the permit.
Assuming that they went the permit route.
Okay, so they built a wall without a permit and it's
Right.
too tall.
Exactly. And those are situations routinely that we deal with.
Okay.
Yep. The neighbors start complaining about, or let me put it this way, the type of wall they built. It is built with corrugated steel, or it's not built with corrugated steel, but it's just a mesh, something or other, that is now wearing out.
So we have restrictions on materials that can be used for
In certain locations, if I'm not right, Britt.
in certain locations.
Correct. Certain materials, certain locations, and other building code issues involve electrical that's not permitted or to code, plumbing. So it's a very broad category.
Okay. Thank you.
So of those 602 active cases, there are a total of approximately 1,173 total violations. Most cases have multiple violations. So specifically, when we break down those 1,100 or so total violations, what we'll be talking about in this presentation is that top number, that 247, so a total of 21% of those violations. These are violations related solely to scrap, debris, trash. So these are your dirty yard cases, things that stand out pretty obviously. Now, 14% of the violations are related to inoperable vehicles, which we discussed fall under a zoning violation, and 12% of the violations relate to the buildings without permits, known as the BWAPs. The important thing to know about the 12% of the violations relating to BWAPs are most of these are old cases that were initiated prior to our current BWAP process. So we've been essentially working through that backlog. And that number, we don't expect it to go up. We are expecting it to continue progressing downward. And 10% of the violations are related to proper use of land. But again, for purposes of this presentation and this proposed ordinance, we are only talking about those 21% of the violations. So this isn't a way to deal with every code issue we have, but it is a way to deal with that 1/5.
Yeah. You know what? This is a work session, so feel free to jump in anytime.
So as I was studying this, on the scrap and debris, I think that's something that we do need to figure out a way to get out. But just in the photo that's right here, wouldn't that be a violation that our fire marshal could write up for? I mean, to me, it would be a fire safety kind of scenario. We have a fire marshal, and I wonder why some of this stuff doesn't fall under the fire code.
Mr. Chairman, Mr. Miller, yes, in some cases the fire marshal could get involved. He's part of our BWAP meetings, for example. and there's a lot of coordination that goes on between the code group and the fire marshal. It's a little bit of a tenuous situation, however, because he has deferred powers from the state. They have certain authority that they don't want to give to us. And then we have a number of fire departments and fire districts that we work with. Some of those departments and districts don't just do protection of buildings, but they also do the education preemption side of that. So in those kind of cases, Mr. Surtees familiar because of dealing with a couple of cases in Gold Canyon, we have to defer to the district to do that proactive work instead of the county. They're the actual agency that's in charge of not just protection, but also the prevention side of that. So we involve them, if that makes sense.
Well, not really, but because certainly after the newspaper article of the 4 units that burned Twilight Trails, I believe is where it was. Of course, I got calls for out in my area from some small RV park, and certainly one was, this is a fire hazard. And I have to agree with them. I mean, they never complained. Nobody ever complained about the stuff around his house or around his unit. But the fire issue is a thing, and they're not covered by any fire district. They're not covered by any. And I just have always, I mean, we always refer to our fire marshal and our fire code, and I just wonder if we can't use that in these scenarios. I mean, and I don't know what we can do with those codes, but I just wonder why we don't.
Mr. Chairman, Supervisor, it's actually fortuitous that you asked that question. I got to think about how to answer it without being too expressive. The actual case that you brought up, that you got the call from, we all met on yesterday. So legal, fire, building safety, code enforcement, we all met with respect to that case and the complaint we received. The challenge that we have and that we discussed yesterday, especially from the legal aspect, is yes, the fire marshal is involved. Yes, there's a potential issue there that we're investigating. If the fire marshal gets involved and confirms what the complaint is, we would have no choice but to shut down that entire RV park and leave all those people homeless. That's a very challenging thing, from our perspective, and certainly would be from your perspective if we had to do that. He's made some allegations that are pretty serious. So at this point, what we decided yesterday is we're going to do some further research. We're going to go on site. We're going to contact the utility company that's associated with that. But we started a code enforcement case because there's a different set of results, if you will, in their expediency and their severity by going through the code enforcement process instead of going through the building official and or the fire marshal to deal with that immediately, if that makes sense. And that was a meeting we just had yesterday.
Okay. Well, I haven't turned in the one I haven't even reached out to anybody on the one that was called into me yet, because I knew this meeting was coming up, so I wanted to.
I'm guessing it's the same one.
Well, we'll see.
We had 2 emergency meetings yesterday on it.
I don't know. We'll see. I haven't shared it with anybody yet.
So the next few slides are photos from 2021, 2022, 2023, and 2024, just to show you some either previous cases or currently ongoing cases that this proposed new replacement ordinance would address. So there's your scrap, trash, debris. Those would be the violations that we easily see. Next, this is a dilapidated home with the resulting scrap, trash, debris in the front yard. Obviously, another dilapidated building. And another, we do have several of these cases where whatever structure was there has burned down, and we have the resulting debris that's been left on the property, and it's blowing all around and oftentimes into neighboring properties.
Can I ask another question? I'm
Mr. Chair,
sorry,
quick.
because I look at this. Now, there's a property owner?
In some cases,
Or is it a bank that is the property owner?
There is usually a property owner,
Okay.
but whether or not we have contact with them or can find them, that is oftentimes the issue.
Lots of these units, though, to have a lien against them or have some type of other, in other words, there's another partner in this thing called the bank or a mortgage company. Do we ever reach out to them?
Yes, oftentimes we have to reach whoever has the note on the property where the issues exist, yes.
What kind of responses do we get from them?
Sometimes good, sometimes no response. It kind of depends, and that's why we have the notification and go through the process.
'Cause I think they got the money.
That's the assumption. Yes.
Okay, all right.
Mr. Chair, quick question. So in that case, like something like this picture here, so it's a code enforcement issue, right? Okay.
Yes, sir.
So code enforcement is complaint-based, right?
Yes, sir.
So in this case, I mean, that could just be sitting there and nobody'd say a thing and what the heck, right? But now you say it's blowing around, so the neighbors are complaining, so now we're in on it. So at what point are we able to clean and lean something like that?
That's exactly what we're proposing today.
I know that's where we're going, but
Yes, sir.
I'm just asking.
Well, as you know, we have a process that we go through, and our process is not designed to be a hammer. Our process is designed to be a handout. So we work with folks over a period of time, provide notices, give them opportunities to come into compliance. And as you've seen before, sometimes that takes 2 years, sometimes that takes 6 years until we finally go to Superior Court. And in the meantime, when we're trying to work with the property owner to clean up the property, the people that are complaining just continue to get madder and madder and madder as they go through first notification, second notification, mitigation plan, then it goes to the hearing office. Then after the hearing office decision, they may extend it, and then it goes after the hearing office decision, oftentimes to appeal to Superior Court. It can take a whole lot of time, effort, and frustration by all parties involved. Yes, sir.
And that's this presentation. And we're going to get to it because I know Ian.
Yes, sir.
We talked yesterday, so we're going to get there. I'm just putting the question out there.
So on that note, this is our current process. This is the way all code enforcement cases currently progress through the enforcement system. You'll see in the top right corner, there's a reference to a statute. That is the authority that all of these cases are proceeding under, 11-815. So as we discussed, first there's a complaint, and then a code enforcement officer goes out to the property to determine if, in fact, there are violations present on that property. Now, that begins the attempts to resolve the violations through voluntary compliance. Now, the amount of time that it takes to attempt to resolve these violations, it varies. It varies on the level of cooperation, communication, if the ball is moving forward in any way. Code enforcement typically, in every case that I've seen, works with the property owner for as long as it takes to get them into compliance until those efforts stop. Now, if there is voluntary compliance, the case ends right there and nothing else happens. Now, in the event of noncompliance, this is when code enforcement would generate a complaint, and that is filed with the civil hearing office. This is where the civil hearing office gets involved. And then there would be a hearing where the property owner has the right to be present, right to present their case, and the hearing officer makes a decision as to whether or not there is a violation or violations on the property in question. If the civil hearing officer finds that there is a violation or violations, the typical thing, in every case, the hearing officer will order abatement of the property, meaning get rid of those violations, and the hearing officer has the ability to assess a fine of up to $750 per violation. Now, it should be noted that the civil hearing officer could be issuing fines per day that the violation is ongoing. That is not currently being done. Typically, the hearing officer will order the abatement and then issue that $750 fine, which is from that's the top end fine for a Class 2 misdemeanor, which is what these fall under. Now, the civil hearing officer will give typically 30, 60, 90 days, whatever the circumstances warrant, for the property owner to abate, correct the violations on the property. And if that's still not done, that is when the case gets referred to the county attorney's office from code enforcement. They say, hey, this is the situation, here's the case history, will you look at this and consider filing a lawsuit? And that lawsuit is to obtain an injunction, basically getting judicial authorization, a court order to go onto the property and give the county the right to enter and clear the property.
Mr. Chairman, if I could also just add on to what Ian was saying, you have to also keep in mind that a good number of those cases that go to the hearing office, the party doesn't even show up. Are some of our best efforts to try to get them notice, to give them attention to this, there is probably 25 to 30% of the cases that they just don't show up. They're just thumbing their nose and basically, don't care. So, I mean, I do need to make you aware that we have those situations where we still put on the case. We still make the record. The hearing officer will still impose a fine on it. But the other party, they could be out of state. They could be, just feeling they don't want to participate in the process. So I want to bring that to your attention.
Do you have a percentage?
We'd have to go out and check, but I'd say it's probably about 25%. I think
25% don't show, or 25% do show?
Don't show.
25 don't. So 75% of the people do show.
Yeah.
Okay.
And I would say that that 25% is a pretty conservative number. And it should be noted that just because a case is referred to the county attorney's office for consideration of a lawsuit, all we're doing is considering filing a lawsuit. We don't file a lawsuit on every single case that is referred to us. I know that I myself have declined probably between 4 to 7 of these cases based on what we're seeing in terms of the violations, the available evidence. So there is still that second set of review going on. We're not just rubber stamping saying, here's a lawsuit. So I just wanted to put that out there. So because of this current enforcement process, there are some inefficiencies. I'm sure the board is familiar with some of these. Essentially, what we're left with is we have some of these basic code violations, these scrap, trash, and debris cases that take an inordinate amount of time to resolve. You have a member of the community asking, why is this still going on after, a year and a half or a year? And that is part of the goal of this new ordinance. We are trying to address those more basic, straightforward violations, the violations that you can drive past, look at, and go, I don't think that is to code. And another issue is the amount of not just time for the process to go through, but we're using a lot of county resources and time to go after these relatively straightforward and obvious violations. So this brings us to the potential new option which is being presented to you today. So this would be under ARS 11-268, so we're shifting statutes. And it should be noted that 11-268, there's a quote there, and that quote is directly from the statute. And it requires the Board of Supervisors, by ordinance, to compel the owner, lessee, or occupant to remove trash, weeds, filth, debris, or dilapidated buildings from property. So per statute, we have to have an ordinance. Good news is we have an ordinance. It's that 11099-RTO. The bad news is it was approved in 1999 and has not been updated since then. And that is what we are proposing to do. The statute has been amended in 2011 and 2013, and because of these changes, obviously our ordinance is outdated, and we just really don't use it anymore because it doesn't apply to what we need it to. So the new proposed ordinance as to the scrap, trash, debris, and dilapidated buildings is here. The first two steps are the same. We would only be responding to complaints, and by we I mean code enforcement, and code enforcement would go out to the property to determine if there is a violation or violations, and if a public nuisance exists. Now, this is where it changes at step 3. If such a violation exists, code enforcement would provide a notice to abate. Now, that notice to abate essentially contains the information of what violation or violations were noted, the deadline to abate, the county and informing them that the county has the right to abate if the violation remains after 30 days. And it also provides the property owner or resident how to appeal, instructions about if you disagree with this notice, if you don't think your property is in violation, or you would like to contest what we're seeing, you have the absolute right to appeal this notice. And that is, those steps are outlined in number 4. So if that notice to abate is issued on the property, it also contains an estimated cost of abatement. So that estimated cost of abatement is generated by a code compliance officer or a qualified contractor. So, for example, someone has an amount of scrap in their yard. The written estimate would say, we're estimating this is about $5,500 to remove. That would be included in the notice to abate. Now, the reason that's important is because that's the number the county is held to. The property owner would not be on the hook for anything above that number, and that's per statute. So if the county goes and it costs $7,500 to abate, the county has to eat the $2,000 because the property owner is only responsible for that cap on the written estimate. So if the property owner receives this notice to abate, then they choose to appeal it. They go to the civil hearing office. The civil hearing officer would, as they're currently doing, hear the appeal, find whether or not there's a violation or violations on the property, and make their decision. If there is a violation, the property owner would have 30 days at least to abate, and that's something that you can change this number. You have the authority to do it. The statute states they should have at least 30. So if that number is increased, that's something that you have the absolute power to do. And otherwise, if the violations remain after that period of time, the county can abate. It gives the county the right to abate the property. And that's it. That's the end of the process. There's no superior court. There's no presentation to the Board of Supervisors about the case. It essentially ends at the civil hearing office level. So in cases where the county must abate, the costs become an assessment against the real property and essentially ride with the property. And as I previously stated, this assessment will not exceed the written estimate in the notice to abate. We're not going to be in the position of, oh, you said it was $5,500 and now you're coming after me for $7,500. We are prohibited from doing that under this ordinance. Now, the notice of assessment on the property owner has the same right to appeal that they do with the notice to abate. They can go to the civil hearing office if they would like to contest the amount. They have that absolute right, and they're given the same hearing rights that they have if they were contesting the violations. So, say there's an assessment that's unpaid after 30 days, then that is recorded against the property, and it's just a lien against the real property.
Can I?
Yep. Supervisor North.
So, in the construction world, we, before I'd ever deliver one stick of lumber to a site, I would pre-lien the job site. Would we file an instrument similar to that in this case? Would we do a pre-lien so that everybody's noticed, including the lender, that there was going to be some type of incumbent type of fund that's going to be required to be paid? Does that make sense?
I understand what you're talking about. In this situation, I don't believe we would have the ability to pre-lien until after we've actually conducted it, and then you would have that abatement notice, the amount, that would become the lien because we have actually undertaken and done that. The pre-lien is just, we're going to do this, and you need to comply.
That'd be close
We
to
wouldn't
step 5. I don't know.
We wouldn't be recording it. I would be hesitant to record anything like that until after the fact, that you've actually incurred those costs.
Okay. But again, I'm going to go back to the lending or the owner, if it's a leasee, something that everybody understands there's going to be an assessment on this piece of property that, and I don't know, did we get first position in a sale of that? I mean, after we file that lien and
We wouldn't get first position. The bank's always going to have a first position, but they're going to want to. If you try to sell that piece of property, you're going to have to clean up those liens to be able to get clean title to it and sell it.
right, okay,
I think it's anything similar to what a contractor would do.
it's similar.
If they didn't pay the bill, they would lien the
And
property.
I'm concerned about who comes up with the estimated amount. I mean, if we ask a contractor to go out there and give us an amount, we contract to him probably for that amount. Then he comes back to us and tells us it's another $2,000. They know the PO was for this much. That's all we're paying. I don't see. In other words, I don't see us on the outside having to pay more, or estimate them really high. One of the two.
Yes, sir. Excellent question, Mr. Goodman, Mr. Miller. What our intent is we have an on-call list of contractors that do this abatement, and it's customary for us to get a quote, and then it comes back to us. There's a review. The procurement office looks at it, and then we authorize those expenditures because we do clean and liens now. This would just open up to a quicker process and probably more success. It is tied to going to the board and asking for some money to be put in a kitty, if you will, to implement this program. The code's just one part of it. The financial part's the second. Our intent as of now would be to get those quotes from the contractors so that if we move forward, we will have an agreement with them, and they'll have to stay within the confines of the estimate that's provided, not for staff to do the estimate, if that helps.
Yeah, that's good.
Mr. Chair, quick
Yes,
question.
yes.
On the abatement process, you had 30 days to clean it up. Can we do that on a case-by-case, or do that wouldn't be discriminatory? I mean, if we said, oh, you know what, in this case, we can give you 60 days or 45 days?
I think we could do that. We would just have to craft the ordinance with that kind of flexibility. Because the statute, as Ian said, requires not less than. Yeah.
So my suggestion would be to put it, if we can do that and you craft it properly, that we say 30 days, because otherwise it's 60 days, and but I need 90, I need, it's like, go to the quick route, and then if we have to adjust it, we could.
Right. And I think internally, administratively, we'd be working with staff, code staff, and we would recommend that you can, if they're making progress or, a valid excuse, whatever it may be, you have that ability. We wouldn't necessarily go out there on day 31 and start the process. You've had 30.
I understand that. But I'm just saying, but instead of writing it where it's super lean, make it tighter so that we can adjust it for necessity.
Yeah. I mean, shortening, we shouldn't take 6 years to get something done. Yeah. And I guess my question is to the staff, what kind of target frame are you looking at? Would you like to try and see any of these never go more than a year? Or, do you have some kind of a...
Absolutely. Our target is full process 6 months. I mean, that's the intent based on the slide that Ian showed before. Understand there's some push to that, especially if they appeal to the hearing office, and it goes through that process because the hearing officer has the ability to extend that case. But the intent is let's get these things done in less than 6 months.
Are those appeal time frames in statute, or do we get to put them in our ordinance?
That would have to be placed in the hearing rules, but as it stands now, they don't have a limit on what they can do. As a matter of fact, that's been a challenge for us. So we just did a training last week and brought in some outside folks, specifically from Maricopa County, to do a training with all of our hearing officers on what they should be doing, potential changes to their process, guidelines to operate by, those kind of things. So we're trying to cover it from all angles.
Okay.
And if I could also just add to that, The ordinance that we've been crafting, we're not the only county that has an ordinance such as this. Mojave County has had one for a number of years. They've utilized it a few times. We have that was our template, if you will, that we started with. So I want to let you know that, do you remember other counties too, Ian?
Yavapai has one. Maricopa has its own. Those are two I can think of off the top of my head.
I believe Cochise.
Cochise.
Okay. From the voice in the back.
So this is essentially where we're left if this replacement ordinance is adopted. The three tracks are essentially the three options that could happen. If the notice to abate is not appealed by the property owner, as is often the case, the county essentially just needs to wait 30 days, and then they have the right to abate the property because the property owner is not contesting it if the violation or nuisance remains. So it's essentially a 30-day countdown clock. But again, that number can be adjusted by the board because it's ultimately the county's ordinance. It just has to be at least 30. Now, if the notice to abate is appealed and the hearing officer finds that violations exist on the property, the county may abate 30 days after that civil hearing office decision, the property owner has at least 30 days. Again, that number can be adjusted, and it's ultimately up to whether that number is put into the ordinance itself or if we're going to leave the discretion with the hearing officer.
So, Ian, I have a question in regards to what kind of flexibility does the hearing officer have? I mean, obviously there are some cases that's going to come before them that they can't afford the cleanup or anything else of that nature. They're going to have that kind of flexibility to determine how much help is going to be needed, and do we have resources available to them that they can use some outside help that would donate services to help? Especially in those situations where they flat out just can't afford it.
That's an excellent question. Mr. Chairman, as you know, we've tried to do these before, and we've tried to cooperate with some entities to do some assistance. So the way that we've done that in the past is we have entities that come forward that want to help, and some of them were done this last year, as you know, in your area. We maintain a list, and when entities like that are looking to do a community service project, et cetera, we can provide that. But we don't have a program that we've developed with specific vendors or charities to do individual cleanups. The intent with this is that the county would pay for the abatement and then lien the property.
And I understand that there's going to be situations where that's probably the last, and I think that's where most of us is. This is the last. That should probably be the last resort that we turn to do.
The other answer to your question, now that I think about it, is the hearing officers actually have, a lot of autonomy in terms of making their decision, and that was shared with them last week at the training as well. As they do have autonomy as long as they follow the rules. They are quasi judicial, and it's not uncommon for them to allow folks more time to comply.
All right, thank you.
And the third option would be if the notice to abate is appealed by the property owner and the civil hearing office finds that there is in fact no violation or violations on the property, the county does not have the right to abate and the matter is closed. So these are kind of your three tracks that we're left with here under the proposed replacement ordinance. So just to sum up with where we're at, what we're ending up with. So this would put us on two essentially tracks of code enforcement. We would have the scrap, trash, debris, and dilapidated buildings. Those would be proceeding under the replacement ordinance, the more streamlined, quicker process. And the zoning violations, which we previously discussed, would be proceeding under our current process as they do now. So this would not be dealing with all of our cases, but this would be an efficient way to deal with the existing 21% of our violations that relate to trash, debris, and dilapidated buildings. I think 6 months is probably the outer limit of how long the majority of these cases would take under the new ordinance. So I think it would be reducing the current process as to these cases substantially.
Okay.
So are there any questions from any member of the board?
No, I don't think so. Thank you.
That's enough.
Yeah. Oh, I'm in charge. Item number 4. We have a presentation discussion covering the assessor's process, the BOE process contract, and legal considerations. Focus on reviewing the assessor's office process prior to citizens submitting petitions to the clerk's office. Is John Ellenwood here?
Yep.
Oh, there you are. Are you presenting?
Mr. Chairman, members of the board, John Ellenwood, Chief Deputy Assessor. I have a very small introduction, and then I believe Natasha has a PowerPoint to go over the process. So the topic is Board of Equalization, and what I can address is how you get there. We send out annual notices to about 260,000 properties. The biggest one is the February mailing to real properties. And a notice triggers an appeal. Every time we notice somebody about their property, they have an appeal right. And those dates are different depending which notice it is. Generally, the main one is 60 days. During that appeal period, they may file an appeal with our office, which would be for, there's no charge to it, and we have a set time to evaluate the appeal. If they do not agree with our decision, they may come over to the board and file an appeal with you or the Board of Equalization. And that's how they get to the Board of Equalization. So they've already met with us and discussed the case. And if we agree with them, then that is settled. If we don't agree with them and they choose, then they can trigger the Board of Equalization. The Board of Equalization is a judge for us. It's a hearing where our work is evaluated. So it's almost a conflict for us to pick the hearing officers. So at this point, I was planning on letting the board evaluate it unless you had any questions.
Just clarification, because by coming over here and asking for a hearing, it's not us. It is the Board of Equalization. They don't have an option to have us hear it, correct?
Chairman Goodman, Supervisor Miller, in the statute, it's ultimately your decision whether to hear them yourselves, to appoint a hearing officer, or to go through the Board of Equalization.
Because
What are we at now? What are we
they
at
go to the
now?
Board of Equalization. I've not seen anybody come over here and ask us to hear their case. I mean, it
Well,
could have
they
happened, and I don't know about it.
That's happened in the
but-
past, and we gave it over to the Board of Equalization.
Exactly.
To stop
So-
the judicial
So
issue.
that option to hear it in front of us is not available.
Well,
At this point.
it could be available to you. The statute has, and it's 42-16-102, in each county with a population of less than 500,000, so that is us at this point in time, the board of blah, 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 the Board of Supervisors constitutes a county Board of Equalization. So, but the county Board of Supervisors by majority vote may contract with the State Board of Equalization to review and hold hearings and make the decisions. So we currently contract with the State Board to do that, but you could be doing that.
Okay.
Chairman, if I may further clarify
You
that.
bet.
Pursuant to ARS 42-16103, in the event the Board of Supervisors act as the Board of Equalization or chooses to appoint a hearing officer, those individuals must meet minimum qualifications. Qualifications shall include experience in at least one of the following areas: real estate, hearing property valuations, abatements. So if the board chooses, therefore, they would need to attend training from the State Board of Equalization, and they would need to meet at least one of those areas of expertise.
Okay.
Mr. Chair, that's what we've had a discussion previously about. Do you want that training? Do we need that? We already have people that are qualified to do that.
That's why we hand it to somebody that's qualified.
That's why we
Right.
set it over that way.
Okay. Yeah, that's why we moved that direction. Okay.
Okay, that helps.
Mr.
Go ahead,
Chairman,
Supervisor Kavanaugh.
If trying to think of the name of the gentleman who lives out at Mount Lemon, if he were here today, he would probably say that he didn't get a fair shake at the hearing, Board of Equalization. He went through and exercised his rights in tax court and
Prevailed.
yeah, he prevailed. And
Right.
I think there's still an issue outstanding with the assessor's office where some sort of a. Do you have a memory of that, John? What is the current issue?
Chairman Goodman, Supervisor Kavanaugh, the judge or the commissioner in that hearing ruled that there be a full cash value and that it be ag property.
Okay.
That was the extent of the rule. So we have a full cash ag triggers a 15% assessment ratio at Class 2. Our reading of the decision, and I believe the county attorney's reading as well, was that we're done. My understanding is the tax court is non-appealable. So they told us the full cash, and they told us the legal class, which determines the assessment ratio. That's it.
Okay.
So my point, Mr. Chairman, is we're elected. There are not. I think we've had this same exact discussion. There are not these many of cases that come up. We represent the people in our respective districts. How high a burden would it be for, say, Steve Miller, who's already basically an expert in real estate and housing, to go to a class and finish up so we can be closer to the constituents and represent them better. And I think this situation may have ended much, much sooner without the extraordinary legal costs to Rich Perrineau if we had some training and did this. So that's my argument.
And Mr. Chair, one other
Yes.
thing, that turns us from a legislative to judicial body. And that, in my
That was part of the reason.
that was one of the reasons that we've gone this other way, because then we're playing both sides of the branches.
Okay.
Wasn't that what the state law allows for, right? Under 500,000? It allows us to do that.
It allows us to do that. You're absolutely correct there. However, I think as a board as a whole, we determined that we're better served in this situation, or as far as equalization of the taxes, to use the outside, the Board of Equalization. So that was determined by the board. So I guess at some point, if we decide to rescind that, that's got to go before the board again, and then we, as a board, collectively make that decision.
Mr. Chair,
Correct.
that also keeps it under 500,000. If we did another census count, we'd be over 500,000. So that's a moot point.
Yeah, that's true.
Can we use midpoint census?
But irregardless, I think it was a decision by all of us based on what Natasha just read. There was a lot of work on our end that was going to happen. Go ahead.
It's
Supervisor
either
Miller.
it's not. In other words, we've chose to go down the Board of Equalization, however you want to look at it. But if an individual came, it can't be just a one-off. We either do them all, or we can't just do one.
Right. It's got to be them all.
Correct.
It's all or none. Am I right?
That is correct.
Finally.
And then
And how many would that? And how many would that be, in your estimation?
So we don't have to estimate. We can actually give actual figures for 2023. And that is a part of the presentation that I have here, so let me pull that up for you.
Okay.
Let's just do it. Do the presentation.
Mr. Chairman, any other questions, or are you all set?
Not at this time.
Thank you.
Thank you. Don't leave yet, though.
So Supervisor McClure, to answer your question, we will go to that particular slide in the presentation. And in the presentation, this is the only page that has been updated from what was previously attached on the agenda. So last year in 2023, the State Board of Equalization evaluated 288 parcels that we received in the Clerk of the Board office. That equated to 53 hearing cases. So total 288 parcels that had to be reviewed.
So more than one a
last
week.
year alone.
That's just one a week. I mean, I'm just looking at that, and we don't have meetings every week, so you'd have sometimes two hearings.
2 or 3.
Right.
There's a little bit of a nuance that you have to have them done, depending on what type of case it is, by a date certain. November 15th, December, and so forth.
Yeah, it depends. Currently, there are 5 different appeals that taxpayers can come before the state board with. And each one of those appeals have a different process and statutory guidelines and deadlines for those appeals. But typically, drop dead date for all appeals are mid-December.
So you could have 6 or 7 in one meeting.
That is correct.
The possibility of that, yeah, or more.
And further noting that one of those appeals, which is our notice of claims, those can come in at any time throughout the whole entire fiscal year.
In the days that they have the Board of Equalization hearings here, they tie up this room all day for the most part, if I'm correct.
Yes. In 2023, we did have 5 hearing dates. And of those 5 hearing dates, yes, the State Board of Equalization, along with the assessor's office, was here in the hearing room for those cases.
So there was 5 hearing dates set, and all those are heard on those 5 dates. Is that?
That is correct. 53 hearings were held on those 5 hearing dates.
Okay.
That would make it an inordinately long meeting with that and other business that we do.
Well, if you can stay awake, it'd be an interesting day.
And chairmen and supervisors, I do have a presentation if you'd like for me to go over that presentation with you.
Yes. Oh. Yeah, I would. Everybody else okay with that?
Yeah.
All right.
Okay.
Cry if you want to.
I cry.
So, of course, we're here today for Board of Equalization. Also, just for the record, if I may, we do have the State Board of Equalization representative here. Mr. George Shook is here from the state if the board has any questions. By request, the overview will cover the current State Board of Equalization process and the possible transition to a hearing officer contract. Currently, the COB office process is through a yearly contract with the State Board of Equalization. Currently, the Clerk of the Board office, we serve as a administrative support. We're almost like a pass-through for the actual State Board of Equalization. What does that support look like? We are receiving, logging, and emailing, and also mailing all of our petitions and the evidence that comes into the Clerk of the Board office. We provide the meeting location, as previously discussed. Normally, those meetings are held here in the hearing room. And we also schedule those meetings with consideration of State Board schedule and then also our assessor's office schedule as well. Sometime the Clerk of the Board office staff, we may attend the State Board of Equalization hearings as well. And then the Clerk of the Board office, we place the actual ratification of these hearings on the Board of Supervisors agenda. The current contract with SBOE delegates the mass majority of the responsibilities to themselves. Again, Mr. Shook is here to provide any details as it relates to those services in which they provide. Last year in 2023, the State Board of Equalization invoice was a total of $2,813.61 for those services. Now, for the COB obligations under the possible transition to a hearing officer's contract. The hearing officer overview. The hearing officer will review the cases, conduct the hearings, and then, of course, make decisions. The standard current contract is typically for 2 years. The current rate from 2020 was $115 per hour, plus per diem of $70 per day. And then also there is a gas surcharge of $50 per day. Also keeping in mind that a lot of the counties that do contract with hearing officers, they also have a contract with the State Board of Equalization for any type of conflicts that might come up. So they're holding contracts, again, with the hearing officer and then also with the State Board of Equalization. The COB office possible transition to a hearing officer contract duties. The staff would continue to provide general administrative duties, and then we would be required to assume full responsibility for all of the existing obligations that are now currently under our State Board of Equalization, excluding only conducting the hearings, of course, which would be held by the hearing officer.
Mr. Chair, quick question.
Yes.
Again, this is all predicated on 500,000 population, so that if we break that, then all this goes away and it goes back to State Board. So
That is correct.
I mean, looking at this, if we did something like this, it would be a very short term.
Very short.
And then it would be, so, okay, thank you.
Okay. Now, review of costs. The current State Board of Equalization contract and estimated cost for possible transition to a hearing officer contract. The Clerk of the Board office, current staff, and that also includes myself, would require State Board of Equalization training to manage this process effectively and efficient pursuant to ARS statutes. And due to the additional workload associated with performing these responsibilities from these 5 different petitions and appeals that come to the Clerk of the Board office, would require hiring additional staff. Also, it would become necessary to hire outside counsel due to the conflict of interest that the county has, because the legal department obligations are with the county assessor's office. Is that correct, Chris?
That is correct. There are occasions where the assessor's office consults with us as legal counsel on the case that they are presenting before State Board. So that would be a conflict. We could not advise Natasha in those duties.
Thank you, Chris. Currently, inquiries as related to ARS are filtered through the state. So any questions or any concerns regarding anything related to Board of Equalization, we currently go to the state for assistance. Hearing officer possible invoice with hearing officer's contract. This is based on the caseload from the previous year of 2023. The projections that you see on the screen have been established utilizing the current rate of $115 per hour for the review of the 288 parcels that were conducted last year. This review is a conservative review with just 30 minutes of review per parcel. So with that would be $16,560 with just reviewing the actual 288 parcels for 30 minutes each. The staff hours for scheduling and inquiries that we currently had last year in 2023 was about 6 hours. That amount would be $690 with a hearing officer. The hearing date costs, based on the actual agenda and scheduling the hearings for 2023, would have been $3,705. So the overview of cost associated with contracting with the State Board of Equalization Services in 2023, again, total was $3,191.61, and the estimated hearing officer cost alone would be the $22,555, noting that that does not include the additional staff for the clerk of the board office, which would be required for us to fulfill these duties pursuant to ARS statute.
So, Mr. Chair, to that point, we profess to be fiscal conservatives, and if this is the case, and we had a bill of $2,800 compared to these other costs and extended costs, that seems to be kind of a ridiculous shift of operation.
You think?
I think, yeah. And so, thank you, Ms. Kennedy, for that presentation. That makes it much clearer.
Thank you, Vice Chairman. And then it's also important to note that the State Board of Equalization's decision, it is not the final decision. The taxpayers have the opportunity to file an appeal in tax court. So taxpayers have an opportunity to appeal with the assessor's office, which John explained. Then they can also appeal with the State Board of Equalization under the current contract that the county utilizes for these services. And then if they're still dissatisfied with the outcome, they then have an opportunity to go before tax court to file another appeal. And as it has been previously stated, I think that it is also very important to note that it is projected that the county will not oversee these cases within the next 6 years by census count. When the county population reaches 500,000 or more, these duties automatically go under the authority of the State Board of Equalization.
Mike?
Yeah.
So we're not going to have another official audit until 2030. We're going to hit 500,000 by then. What is the process for the in-between year audits, and how do we know exactly how many people we have? This comes up a lot.
Yeah, it does. Chris, have you got an answer for that one?
In my best lawyerly answer, it depends. Well, because some statutes and some provisions allow us to, do other than the decennial census. So there are certain times I know for certain grants that we were able to use a different time period, and we do get those interim reports. But the question is that that's not necessarily the official census. And the statute says, a population of less than 500,000, according to the most recent United States decennial census. So you are looking at the official census on that situation.
But even if we were to do this internally, like we're talking, this has been part of the discussion, they still have the right to appeal to the tax court with almost the same result that just what Supervisor Kavanaugh mentioned. It's the same process, correct? Whether it's here or whether it's with the Board of Equalization, it's still the same, correct?
Chairman Gutman, that is correct.
Okay.
Regardless of the process, the taxpayer has 3 opportunities to appeal.
Yeah.
Assessor, State BOE, hearing officer, Board of Supervisors, and then the appeal in tax court.
Yeah, I'm looking at it and just, I mean, the numbers are one thing, but then the other part is the experience. I mean, let's be real, we don't have it.
Mr.
We
Chairman.
would have to hire it. Yeah.
And Natasha, I thought we had a slide as to, I think there were 4 counties that go the hearing officer route that have contracted, and they actually contract with an appraisal service. I can't think of the gentleman's name, Chuck something. I just remember that, reading it, that does perform that. But even when they did, they still contracted with the State Board of Equalization for a situation because there may be a conflict where he is not able to act as a hearing officer because he may have provided an appraisal on some piece of property and so forth.
That is correct. That is not a part of the actual slide, Chris. That is something that we just kind of discussed, sidebar. So currently, right now, there are several different counties, of course, that do contract with the State Board of Equalization. There's 5 counties that currently contract with the State Board of Equalization. Then there are 6 counties that, no, there's 5 counties that also contract with a hearing officer in the State Board of Equalization.
Oh.
And also, I think it's important to note that even in the hearing officer's contract, it specifically states that the hearing officer decision is the final decision before it goes to tax court if the taxpayer would like to appeal in tax court.
So are you, from what I'm hearing, did you say that there are some boards that are actually acting in this capacity, what we're talking about?
So no.
No.
There's not
There is.
any county that's acting on their own.
So I do have
They're taking a piece of it.
3 counties that I do not have a response from, and so I don't know what their processes
Okay.
are.
Okay.
However, 12 of the counties, of course, 2 of those counties, because of population,
Right.
they are already under the authority of the State Board of Equalization. And then we have 5 counties that currently contract with the State Board of Equalization, and then there is also 5 counties that do contract with the hearing officer, but they also contract with the State Board of Equalization for conflicts.
Okay.
I'm not sure
That helps.
if Mr. Shook maybe knows if any counties out there. I'm not aware of any individual counties that are sitting as their own Board of Equalization. The hybrid was either they're going to contracting with the state board or they're contracting with the hearing officer to act in the board's stead.
And also, just to further clarify on the hearing officer, also in the hearing officer's contract, they are being trained yearly by the State Board of Equalization as well. That is one of the requirements that is in the contract, and of course, one of the requirements that is per ARS statute as well.
Okay. Does anybody have any other questions of Natasha or even of our representative from? Okay. All right.
Thank you.
Seeing that there's none, we're going to adjourn.